Okay, you're good.
Mr. Pelletier, do you think you have a location for Mr. Jack where he can go yet?
Yes, we do.
Okay, good. Oh, judge is in.
Ready?
Ready.
Okay. I'll quickly call the first matter. People versus Clifford Jerome Goodrow, file number 2106083. Defendant left the state of Michigan and charged with probation violation for leaving the state without permission of the court. That violated a bond signed by the defendant on June 28th, 2021. Defendant was ordered to show cause today at 9 a.m. why he should not be held in contempt of court. It was mailed to the address that he gave the court. The defendant has failed to appear. The court will issue a bench warrant for defendant's arrest with no bond. Next matter is People versus Nicholas James Halter. This is file number 2108127. Is Mr. Halter available, Mr. Pelletier?
That's not Mr. Pelletier's client, Your Honor. I don't believe.
Okay.
Mr. Jack is Mr. Client. Mr.
Okay,
Pelletier's.
all right. Is Mr. Halter here by Zoom?
Yes, I am. Good morning.
Good morning, Mr. Halter. I can't see you. Are you just by telephone?
Yes, sir.
Okay, thank you. Generally, when the court allows Zoom by electronic means, a video is required. Are you able to do that?
He's up now, Your Honor.
Okay, thank you, Mr. Halter. Is Ms. Denholm available?
Yes.
She is the public defender and she is present during all arraignments in district court to provide an opportunity for anyone charged with the crime to have counsel. I've called the matter of Ms. Denholm of People versus Nicholas James Edward Halter. Again, this is file 2108127. Please state your full legal name, Mr. Halter.
Nicholas James Edward Halter.
Is your mailing address 7157 Quimby Road, Spring Lake, Michigan?
That is correct.
What is your date of birth, sir?
6/9/87.
I have not had a chance to speak with Mr. Halter.
Okay, thank you. Mr. Halter, there is a complaint filed by the state that charges that on or about July 31st, 2021, in Mueller Township of Schoolcraft County, Michigan, in count 1, you did operate a vehicle upon a highway, US 2 and Black Bear Lane, while having an alcohol content of 0.08 grams or more per 100 milliliters of blood. This is a misdemeanor known as operating while intoxicated. It carries a maximum punishment of up to 93 days in the county jail, a fine of no less than $100 up to $500, and or up to 360 hours of community service. You may be ordered to participate in rehabilitative programs, pay for the cost of prosecution, and reimburse the government for emergency response and expenses for your prosecution. And the Secretary of State could take action against your driver's license based on your driving record. Do you understand the charge and the possible maximum penalties?
I absolutely do, yes, sir.
To this charge, you have a number of rights. You have the right to plead guilty, not guilty, or stand mute or say nothing at all. If you plead not guilty or stand mute, we'll set the matter for further proceedings. If you plead guilty, you'll be giving up the following rights. You have the right to have an attorney represent you. If you want an attorney and you cannot afford one, the court would appoint one at public expense. And Ms. Denholm is available here this morning if you wish to talk to a lawyer before you make your decision on how to proceed at no cost to you. Also, you have the right to have a trial by jury. At that trial, you have the right to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court. You have the right to see, hear, and question all witnesses that testify against you. You have the right to be a witness for yourself or remain silent. If you choose not to be a witness on your own behalf, the prosecutor may not comment on your refusal to testify. And you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. If you're on probation or parole and you plead guilty, that could be a violation of your probation or parole. Do you know how you wish to proceed today?
Honestly, because I've never been through anything like this ever in my life, I'm not sure how to answer. I mean,
Would you like to talk to a lawyer before you decide?
I guess, would that be a smart decision for me, or?
I would hear that as a yes, Your
I'll
Honor.
take that as a yes as well, Your Honor.
Give me a
I'm
chance.
sorry,
I would take
I'm
it as a
sorry,
yes.
I've never been,
Are you requesting?
I've never been through anything.
Are you requesting court-appointed attorney then?
I guess, yeah, just a couple questions then. Yes, sir.
Okay, all right. Well, you'll need to fill out an application. If you're qualified for court-appointed attorney, the court will appoint the public defender and will enter a not guilty plea on your behalf at this time. If you change your mailing address, notify the court immediately. Ms. Denholm, do you have a pen, Mr. Halter?
Yes, sir, I do.
Okay, we'll have you write down this phone number, and it'll be your obligation to call the public defender's office as soon as you can. Please state the phone number.
Your Honor,
Area
I have a question, Your Honor.
Yes, sir.
With me being from downstate, in lower Michigan, is there something we can get handled and figured out right now, or are we gonna have to, am I gonna have to come back up here to you guys
well,
and figure it out?
Let's wait and you can talk to your attorney about that. All right.
Okay.
Ms. Denholm will give you the phone number at this time, so write it down.
Okay.
Area code
Yep.
906
Okay.
341
Okay.
7628.
Okay.
And if you'll call that number as soon as we get off this Zoom appearance, and then leave a number where I can call you back, that I will get back to you today.
What was your first name?
Catherine with a K.
All right.
Very
I'll
good.
continue the bond on the condition you not use intoxicants or any illicit controlled substances. Can you follow that?
Yes, sir.
Okay. Next time you appear in court, you are required to wear a shirt, however.
Absolutely.
Okay. All right. Call your attorney and direct all questions to her.
Awesome.
Court will
Thank you
be
very
in
much.
recess on that matter. Thank you.
Have a good day.
Next matter is People versus Jason Kenneth Jack. This is file number 2107116. This matter is set for probable cause conference.
He doesn't need.
Yes, Your Honor. Chad Peltier on behalf of Mr. Jack. Your Honor, can you hear me?
Can, yes. Thank you, Mr.
Oh.
Pelletier.
Oh, okay.
Go ahead.
As far as basically, there's two things that we wanted to cover today. I believe Mr. Noble and I have discussed. First, Your Honor, and just talk with my client, Mr. Jack. First of all, as far as the preliminary hearing, Your Honor, we'd be asking the court to adjourn the preliminary exam. My client would be agreeing to waive the 21-day rule. It's my understanding that we're still waiting on lab results. And I think both sides, Mr. Noble and myself, are awaiting those results. So I believe there's good cause for the court to adjourn the preliminary exam. Two,
All right.
and then the other issue, Your Honor, that we're asking for is for the court to consider a reduction in bond for Mr. Jack. I could go over that after, I guess I would start with the first.
We'll address we'll address that next. I want to address the probable cause conference first. There are lab results that are pending. Any
Yes.
objection by the people?
Let me update the court, Mr. Peltier. I spoke with the investigating officer last night. He is personally driving those up to the lab Thursday to Marquette. Has to do with the amount that was recovered. Didn't want to put stuff in the mail in case something got lost. He wanted to personally do it. He's in Marquette tomorrow, so he's going to be doing that then. So I agree with Mr. Peltier. We've talked about ways to go in this case, but a lot of that's going to depend upon what happens with those lab results on that substance. And that'll also apply to the corresponding case. And I see Mrs. Denholm is still in the courtroom. That'll also apply to the corresponding defendant's case, the co-defendant's case, Ms. Lipinski. So I think that's reasonable. And then that's what kind of leads us into the bond issue. And so I don't know when the court wants to address that.
Okay, well, let's finish the PCC.
Sure.
The witnesses are listed on the complaint. Any additional witnesses by the people for the prelim?
If necessary, there would be a lab official, but I don't know at this point, obviously, since the lab stuff isn't even in at the lab, to get it back from the lab, who that person will be, but that's obviously someone that would be there. There would also be some pictures as potential evidence if need be.
Well, under the preliminary exam rules, you can submit a scientist by testimony or the report.
Right, and I don't have either of those yet, so I don't know who that would be or what that report would say, nor do I have anything I can share yet with defense on that issue.
All right, thank you. Any exhibits would be a lab report, any photographs?
And photographs, yes.
And for the defense, are there any motions that you'd be filing at the preliminary examination other than evidentiary?
Nothing other than an evidentiary hearing, Your Honor.
Any witnesses you wish to name at this time?
None, Your Honor.
Any exhibits you anticipate?
None at this time.
All right. Well, Mr. Pelletier, if you'll contact the court for a new date, stipulation and order for adjournment must be prepared by you with a new date and time for the preliminary examination.
Okay.
In that order of adjournment, okay? And then
Yes,
we'll
sir.
need the waiver of the timeframes from you accordingly. Now, at this time, I'll take argument on bond, Mr. Pelletier.
Yes, Your Honor. On bond, it's my understanding that Mr. Jack's bond is currently set at 50,000 cash or surety. Talking with Mr. Noble, obviously Mr. Jack's address was at West Elk Street, where allegedly the co-defendant lives, as well as where the alleged crimes occurred. So he can't go back there. We have discussed, and I know the court was looking for Mr. Jack to move to a different address. He does have another address to go to. It's 311 South Cedar Street. It's the Harbor Motel. He would have an employer, a Chris Gugula, a Broom 8 is where he would be at. He would be working as maintenance and firewood for Mr. Gugula, I guess. And he has a place to go other than West Elk Street and employment. So we'd ask the court to consider something less than the $50,000 cash or surety based on these new ties to community. as well as he'd be willing also to take any drug testing, or whether the court would want tether or anything like that. Obviously, he'd still be in the area, so he'd be not objectionable to either of those issues. So we'd ask the court to consider something less than the current bond set at 50,000 cash or surety, if the court feels necessary of a tether or testing. Obviously, the court, I'm sure, would require testing, and Mr. Jack would have no objection to any of that. And I believe he would be, I think he would be a good candidate for those type of services. So we'd ask the court to consider that, and thank the court.
Thank you. Mr. Noble, any position by the people on bond?
Your Honor, I'm agreeable to a bond as long as there is a residence. There needs to be no contact with the co-defendant, Ms. Lipinski. That needs to cease. That's obviously a bad situation. Plus, she's a potential witness against Mr. Jack, and theoretically vice versa. And we don't need the two of them discussing the case. So I'm not opposed to the bond being modified as Mr. Peltier suggests. We've explored this case. Mr. Peltier and I have discussed about potential resolutions, albeit we have no agreement anyway, one way or the other, because of the awaiting of the results on the other matter. So I think that a bond is reasonable here.
What quantity of methamphetamine are we talking about?
Very minimal, Your Honor. Well, let me rephrase that. We don't know exactly what the substance fully is.
But enough to
Residue.
not go through the mail.
Mostly residue, Your Honor. It was in a pipe. That's the one. We have two different substances, Your Honor. We have one substance that was found in a car search that was left over in a pipe, and a little bit left over in a little, I'm going to call it a puck. It looks like a little black puck, but very, very minimal in that.
So why couldn't they just be sent through the mail to the lab?
The other one, because if they send it, there'll be nothing left behind. And so what will happen then is if that were to get lost in the mail,
Oh, okay.
we don't have anything
I
for the lab.
thought you had
test.
mentioned before it had to do with the quantity.
The second one, there's another substance, similar situation, that we don't know what that substance is. And so that's going off to the lab. That's going tomorrow. Like I said,
What's the quantity of that substance?
I couldn't tell you exactly because I'm not 100% sure. It's not very much. But the point is that crime isn't even charged yet. All that substance did really was lead us to additional PC to search the motor vehicle. It assisted in the establishment.
What's the prior record then?
Mr. Jack's prior record. I can bring it up here.
It's my understanding. It's my understanding, Your Honor, that Mr. Jack has some very minimal misdemeanors, DUI and domestic violence, maybe, but no felonies.
Okay. According to this, according to what I've got here, and as long as this is the same Jason Jack, we've got a 2003. What is this? DV. A 2004, looks like a home invasion, but that may have been that's what it's saying. An 09, looks like something under 74. And then last but not least, a 2021, this was a domestic violence. I'm not sure what the results of that one were back in February of this year. That's what I'm seeing. And then there's two other things that I'm not sure. They're misdemeanors, but I'm not sure what the results were because there's no judicial segment in the criminal history. So there is a little bit of a history. Most of it's older. No felonies in the last at least 15 years or so. And I'm not sure what that 2004 case is. That predates me by quite a bit.
All right. Well, I've got a couple of concerns. We did send mail to 700 West Elk Street, and it was returned unable to be forwarded. It moved, left no address. I don't quite understand that.
Wasn't he in jail? And that would have been mentioned.
I don't believe Mr. Jack was ever considered a permanent resident of that house. That's Ms. Lipinski's residence, Your Honor.
Oh, okay.
And so that I would guess that's probably the reason for that.
All right. Well,
I believe that's correct, Your Honor.
and the co-defendant is still in jail as well?
No,
Oh,
she's bonded out.
okay. All right. Well, I have some concerns. Obviously the people are alleging that methamphetamine does exist in this case. There must have been some field test.
We have a positive field test for this substance that was found in the automobile of Mr. Jack.
And, you know, I recognize that in the discretion of all this, the court has taken consideration the fact that methamphetamine is actually a scourge on humanity. I'm very frustrated by it. I don't get it. 87% of the people that use methamphetamine become severely addicted to it. And I guess if nothing else, public safety is at issue here. I'm going to continue the bond and deny the reduction in bond. So if we can get an expedition on the lab report and analysis, I'll review this matter at the preliminary examination and we'll consider at that time a bond.
All right, I'll move that as quickly as I can, and Mr. Peltier, I'll reach out to you later on today.
All right.
All right, thank you, gentlemen.
Thank you, Your Honor.
Next matter is People versus Randy Lee Kirkman. This is file number 2108128. Mr. Hugaboom, you're appearing on behalf of the defendant.
That is correct, Your Honor. If I may tell Mr. Kirkland to unmute himself and push his video button so we can see his face. Mr. Kirkland is hard of hearing, so I'm going to repeat myself. Mr. Kirkman, please unmute yourself and push your video button so we can see your face. Now you need to unmute yourself, Mr. Kirkman. Unmute yourself.
Okay.
Thank you.
All right. Please state your full name, Mr. Kirkman.
Randy Lee Kirkman.
Is your mailing address 600 Hallbrook Drive, Midland, Michigan?
Yes, sir. 600 Hollybrook Drive.
Okay, it may be misspelled on the complaint. Is it HOLLYBROOK?
I'm sorry.
Is it HOLLYBROOK?
Yes, sir.
Okay, thank you. What is your date of birth?
My age?
Your date of birth?
Yes, January 21st, 1957. I'm 64 years old.
Thank you. Mr. Kirkman, you're charged that on or about July 28, 2021, in Seney Township of Schoolcraft County, Michigan, you did operate a vehicle upon a highway, M28 near M77, while having an alcohol content of 0.08 grams or more per 100 milliliters of blood, contrary to law. That's a misdemeanor known as operating while intoxicated. It carries a maximum penalty of up to 93 days in the county jail, a fine of $100 up to $500. Court costs could triple that. You may be ordered to perform up to 360 hours of community service, engage in rehabilitative programs, pay for the cost of prosecution, and reimburse the government for emergency response and expenses for your prosecution. Also, the Secretary of State could take action against your driver's license based on your driving record. Do you understand that charge and the possible maximum penalties?
Yes, I do, Your Honor.
Count 2 charges on the same date and location. You did carry a dangerous weapon, to wit, a Smith & Wesson 9mm. whether concealed or otherwise, in a vehicle operated or occupied by you, to wit, a silver Nissan Frontier, contrary to law. That is a felony that carries up to 5 years in the state's prison, a fine of up to $2,500, and mandatory forfeiture of the firearm. Also, DNA identification profiling samples would be obtained from you. Do you understand that charge and the possible maximum penalties?
Yes, I do, Your Honor.
Because count 2 is a felony, you are entitled to have a lawyer represent you. If you want one and you cannot afford one, the court would appoint one at public expense. And you are retaining Mr. Hugaboom, is that correct?
That's correct.
Okay. You have a right to have a preliminary examination, which is a hearing where the prosecutor must prove that a crime was committed and that probable cause exists to charge you with the crime. We'll set that within the statutory time limits and notify you by mail when that is. And Mr. Hugaboom, we work with your office to schedule that so that you can be present for that hearing.
Thank you, Judge.
Judge, do you want those dates or times right now?
Yes, please.
The probable cause conference for August 18th at 9 a.m. and the preliminary examination for August 25th at 11 a.m.
Is 8:18 at what time?
9 a.m.
9 a.m.
And what was the second date?
August 25th at 11. Are you available for that?
On the 25th at 11, I am available. On the 18th, I'm scheduled for a trial, but there's no way it's going to happen. So I'm okay with that also.
All right. And the parties, I will give permission to appear by Zoom for the probable cause conference if there's no resolution. If there is a resolution of the case, the parties will be required to appear in person. Also, Mr. Kirkman, you have the right to remain silent. Anything you say will be used against you. Anything further at this time, Mr. Hugaboom, on behalf of your client?
No, Judge, I think we've already waived meeting, stand mute, and set the PCC date. If you could give me the case number again. I don't have that.
The case number is 2108128.
Thank you. I can now give notice to the prosecutor. Thank you.
Okay.
Nothing. Oh,
Thank you.
Bond conditions remain the same, Judge.
Yes, bond will be continued with the same conditions. And Mr. Kirkman, if you change your mailing address, notify the court immediately.
Yes, sir.
Okay, thank you, gentlemen. That'll complete this matter.
Thank you, Judge. I'll talk to you soon, Randy.
Thank you.
Next matter is People of the State of Michigan versus Michael James Peak, file number 2108130. Is Mr. Peak available on Zoom?
He was planning to appear by Zoom.
No, Your Honor.
Okay. This matter was set for arraignment at 9 a.m. on the charge of improper possession of a firearm in or upon a motor vehicle, a 90-day misdemeanor. Defendant's address is in 112 Eagle Ridge, Robertsville, Missouri, 63072. Again, the matter was set for 9 a.m. It's approaching 9:30. The defendant has failed to appear.
Your Honor, perhaps I could call him. I talked to him at the jail. He would qualify for appointment of counsel, and I have that request here. Maybe you could give me a moment to call him.
The court Unless defendant appears before 10 a.m., we'll issue a bench warrant for defendant's arrest with no bond, unless he should zoom in before 10.
Thank you.
Court will be in recess, and Ms. Denholm, if you'll make sure that he gets a copy of the advice of rights form.
Already gave it to Lamar.
No,
No,
Mr.
that's
Lakeith.
Mr. P.
Oh, okay, he's not here.
Mr. Lamar here?
Yes, he is.
Okay, we can proceed with that if Mr. Noble is available.
Okay.
You have a chair here, please?
Excuse me.
Did you get the advice of rights form?
Did I get that form?
You were given that form today?
Yes,
Okay.
I do believe I signed one.
Oops, that's the wrong one. Has he already signed it?
Yes.
Okay. Yes, that's.
I'm sorry, I don't have my glasses.
Ready? First matter is, at this time, is People versus Robert Maxwell Lamar II, file number 2108125. Please state your full name.
Robert Maxwell Lamar II.
Is your mailing address 6653 County Road 448, Manistee?
Yes, it is.
And what is your date of birth?
9/21/60.
Thank you. Mr. Lamar, the complaint filed by the state charges that on or about July 28th, 2021, in the city of Manistee, Schoolcraft County, Michigan, you did operate a vehicle upon a place open to the general public or generally accessible motor vehicles at 300 Walnut Street, Schoolcraft County Courthouse, while having an alcohol content of 0.08 grams or more per 100 milliliters of blood, contrary to law. In short, it charges you with operating a vehicle while intoxicated. That's a misdemeanor, and it carries a maximum punishment of up to 93 days in the county jail, a fine of no less than $100, up to $500, up to 360 hours of community service could be ordered. You may be ordered to participate in rehabilitative programs, pay for the cost of prosecution, and reimburse the government for emergency response and expenses for your prosecution. Also, the Secretary of State could take action against your driver's license based on your driving record. Do you understand the charge and the possible maximum penalties?
Yes, I do.
To that charge, you have a number of rights. Did you receive the advice of rights form today?
Yes, I did.
And did you read and understand all the rights listed on that form?
I had it read to me.
Okay, did you understand all the rights
Yes.
that were read to you from that form? Yes?
Yes.
Okay. And then did you sign and date it?
Did I?
Yes, you.
Yes.
Okay. To this charge, you have the right to plead guilty, not guilty, or stand mute and say nothing at all. If you plead not guilty or stand mute, I'll set the matter for further proceedings. If you plead guilty, you'll be giving up all the rights listed on the advice of rights form, including the right to have a lawyer represent you at public expense if you could not afford one. And Ms. Denholm is available if you wish to consult with her on how you want to proceed today. If you're on probation or parole for any offense, a guilty plea could be a violation of that probation or parole. Ms. Denholm, do you know how Mr. Lamar wishes to proceed?
He will stand mute on this case.
The court will enter a not guilty plea on your behalf and set the matter for further proceedings. If you change your mailing address, notify the court. Now, there's a condition of your bond that you not use any intoxicants or illicit controlled substances. Can you follow that?
Yes, sir.
Okay, it's important to follow that because if your bond is revoked, you do not have a right to have it reinstated. So you'd be held in jail until the case is disposed of. So it's very, very important.
I understand.
So make sure you follow the rules on that, okay?
Absolutely.
We also have file number 2107105. The court had began to arraign you on this case back on the 28th, but you drove to the courthouse and you had consumed alcohol according to our testing equipment. So the court postponed the arraignment until you appeared here today for arraignment. On that file, it is charged that on or about June 23rd, 2021, in Hiawatha Township of Schoolcraft County, Michigan, you did fail to provide 2 or 3 animals with adequate care, or negligently allowed 2 or 3 animals to suffer unnecessary neglect, torture, or pain contrary to law. That is a misdemeanor known as abandoning or cruelty to 2 or 3 animals. It carries a maximum punishment of up to 1 year in the county jail, a fine of up to $2,000, up to 300 hours of community service or any combination of these penalties. A consecutive sentence may be imposed for any other conviction, and you may be ordered to participate in a psychiatric evaluation, and you may be ordered to pay for the cost of care, housing, or veterinary care as applicable, and you may be ordered not to own or possess an animal. Do you understand the charge and the possible maximum penalties?
Yes, I do.
To that charge, you also have the same number of rights that were listed on the advice of rights form that you signed earlier. Do you understand that?
Yes.
And we'll have you sign an additional copy because this is a separate file. All I need is your signature and today's date, which is August 4th. We have your address.
Your Honor, I believe I was appointed previously.
Yes, I do have an order appointing you to represent the defendant on this file previously.
And I'm also asking that the court enter an order of appointment for file number 125. Be on
Okay,
the same basis.
all right. The court will sign that order appointing you to represent the defendant. Well, you have the right to plead guilty, not guilty, or stand mute and say nothing. If you plead not guilty or stand mute, I'll set the matter for further proceedings. If you plead guilty, you'll be giving up the rights listed on the advice of rights form. Also, if you plead guilty, if you're on probation or parole, that could be a violation of your probation or parole. Ms. Denholm, how does the defendant wish to proceed?
We'll be standing mute as to that charge as well.
Not guilty plea will be entered on your behalf. We'll set the matter for further proceedings. Stay in touch with your attorney just as if you hired her. Do you have any questions?
Not at this point.
Okay, thank you. You're free to go.
Thank you. This is mine.
Yes, that's yours.
Court's in recess until 10 a.m.
Hello? Like,
Okay.
No, Martel.
Are you ready?
Yeah, I don't know. Go.
Martel.
They don't tell you the code either?
No, I keep out of old force of habit, I keep entering the old one.
Michael?
yes, I'm here.
Okay. All right, good. Just stay where you're at. The judge will
Alrighty.
be in- And then we're just gonna be entering a not guilty plea today, and then we'll
Okay.
work out details of where we're going from here.
All right.
How was your trip back?
It was pretty good. Made it safely.
Yeah, uneventful is the best.
Thank you. Thank you.
You got a lot of background noise? What's going
Yeah,
on
I'm
there?
at work.
Okay,
This is the quiet spot I could get to.
all right. You are wearing a shirt, right?
Yes, I am. I don't know how to use this whole Zoom thing. I never used it before, so I don't even know what I'm doing.
Well, obviously we can hear you, so there should also be a video button.
Okay, okay, there we go.
Sorry for a minute. Second.
There you go.
Oh. Ah, there you go. Okay. Judge will be in shortly.
All right.
We had a guy show up by Zoom this morning with no shirt on, drinking his
Oh.
coffee.
Yeah, I'm at work, so I got a shirt on.
Not impressive.
One eight seven. Is this what now? Or is this a breath test?
I think that's probably normal.
Yeah,
Right now?
Yeah.
I could tell when I was talking to them in the hallway.
Oh, me too. That knocked me over.
Well, I think I.
All right, judge will be in just a moment.
All rise. Back in session.
Please be seated. Court will be back in session. Next matter is People versus Michael James Peak. This is file number 2108130. This matter is set for arraignment. Please state your full name, Mr. Peak.
Michael James Peak.
Is your mailing address 112 Eagle Ridge, Robertsville, Missouri?
Yes, sir.
And what is your date of birth?
4/11/91.
Mr. Peak, the complaint filed by the state of Michigan charges that on or about August 1st, 2021 in Mueller Township of Schoolcraft County, Michigan, you did possess in or upon a motor vehicle or other self-propelled vehicle designed for land travel an unloaded firearm, which was not a pistol, to wit, a 9mm Ruger pistol. That seems like language is.
We have something worked out, and this is a fictive arrangement.
Okay. So was it a pistol or not?
It was.
Okay. While not taken down, enclosed in a case, or carried in the trunk, or otherwise inaccessible to the interior of the vehicle, contrary to law. That's a misdemeanor that carries up to 90 days in the county jail and a fine of up to $100 with mandatory forfeiture of the weapon or device. Do you understand the charge and the possible maximum penalty?
Yes, sir.
To that charge, you have a number of rights. Did you go over the advice of rights form with the defendant?
I did.
And did you understand all the rights, Mr. Peak, that are listed on the advice of rights form that Ms. Denholm went over with you?
Yes, sir.
Okay. All right. We'll indicate on the record that you've received the advice of rights form by having it read to you and that you agreed that you understand it. if you have the right to plead guilty, not guilty, or stand mute and say nothing. If you plead not guilty or stand mute, I'll set the matter for further proceedings. If you plead guilty, you'll be giving up all the rights listed on the advice of rights form. If you're on probation or parole for any offense, a guilty plea could be a violation of the probation or parole. Also, it appears as though you requested a court-appointed attorney, and the court has signed the order appointing Ms. Denholm to represent you in this matter and finds that you are qualified. Is there a plea agreement in this matter?
There is, Your Honor, and that's where it got a little goofy when you were reading the arraignment. Technically, under Michigan law, this would be the felony carrying a concealed weapon because of the firearm, because it was a pistol. But the people are, given the fact the defendant was from Missouri, where what he was doing was legal, and a misunderstanding of Michigan law and what its applicability was to his unique situation, I believe that this is an appropriate charge. So it's going to be the plea to the count as charged, and there will be a forfeiture of the weapon as required, and that will suffice for people's. Thank you.
Okay, thank you. And so in lieu of charging the defendant with a felony of carrying a concealed weapon in a vehicle, the people have agreed to charge, although it is a charge that seems internally inconsistent, the people have agreed to reduce the charge to improper possession of a firearm in or upon a motor vehicle under section 239 of the penal code.
That's correct, yeah.
Yes. And it's understood that the weapon would be forfeited.
We further have an understanding that the prosecution would be joining in a recommendation that there be no jail time assessed.
That's also correct.
And that
No immediate jail.
Right, and that Mr. Peak would be allowed to continue to reside in Missouri.
Okay. So with that clarification, that's your understanding of the complete plea agreement?
Yes, Your Honor, we're basically looking at the court imposing a fine, doing adequate time for payment of the fine, and then closing the file.
All right, is that your understanding of the complete plea agreement, Mr. Peak?
Yes, sir.
Other than the plea, on behalf of your client, then pursuant to the plea agreement, Ms. Denholm, what plea does he wish to offer to the charge contained in the complaint?
Mr. Peak, are you comfortable with going ahead on this basis?
Say that again?
Are you comfortable with going ahead with?
Yeah,
the plea?
I want to plead not guilty and no jail time.
Okay, do you want to plead guilty with the understanding that there would be no jail time? You would have a misdemeanor conviction on your record.
I don't know. I'm kind of confused. I've never been through this situation before. I'm a first-time offender, so I
talked to Mr. Hang on one sec. I talked to Mr. Peak about the possibility of this
Do you
kind of
want more
resolution.
time to discuss this matter before we proceed?
Yes, I would ask.
We'll take a short recess on this case.
Okay.
It's time for the next case. Mr. Peak,
Please
you'll
hang
need to
in.
rejoin the Zoom after you've spoken with your attorney. She'll be calling you shortly and she can speak with you about the case, and then we'll reconvene as soon as you're ready. I want to make sure you understand your options here and you understand what's going to happen.
Okay, me too. Thank you, sir.
Okay, thank you. So Ms. Denholm will be calling you shortly.
All right,
All
so
right,
you
thanks,
can
sir.
close your Zoom call. I'll call you in a few minutes.
And Ms.
Okay,
Denholm, the
thank you.
microphone right there.
Oh.
So when you speak, so
Directed to the ceiling?
yeah.
Okay.
Next matter is People versus Caleb Ackley. This is file number 2107117. This matter is set for plea and sentencing on a charge of domestic violence. Please state your full name, sir.
Caleb Ackley.
Is your mailing address still 607 H Street, Manistee?
Yes, sir.
And what is your date of birth?
5/9/91.
Thank you. Is there a plea agreement in this case?
Your Honor, I believe the defendant is going to plead guilty to domestic violence subject to sentencing under 7694A. We've spoken with the victim and that's acceptable to her.
That is our understanding as well, Your Honor. And there will be a referral to
Specialty court?
specialty
Okay,
court. Yes.
thank you.
People have no objection to that if that's deemed appropriate.
All right. Did you receive the advice of rights form again, Mr. Ackley?
Yes, sir.
And did you read and understand all the rights listed on that form?
Yes, sir.
And did you sign and date it?
Yes, sir.
Do you understand that by accepting the plea agreement in this matter, that you'll be giving up all those rights and there will not be a trial of any kind?
Yes, sir.
Are you currently on probation for any offense?
No.
Thank you. On behalf of your client, Ms. Denholm, what plea does he wish to offer to domestic violence?
And I would offer a plea of guilty pursuant to the terms of the plea agreement, specifically the 769-4A.
Is that guilty plea entered with your consent, Mr. Ackley?
Yes, sir.
Other than the plea agreement as stated here today on the record, has anybody promised you anything in exchange to get you to plead guilty?
No, sir.
Has anyone threatened or forced you to get you to plead guilty?
No, sir.
Are you pleading guilty freely and voluntarily and of your own choice?
Yes, sir.
Were you in the city of Manistee at your home when this happened here in Schoolcraft County?
Yes, sir.
And did that happen on July 27th recently?
Yes, sir.
And did you have a dating relationship with Megan Myron?
Yes, sir.
How long have you been dating?
A year and a half.
Did you get into an argument with her?
Yes.
And tell me what you did that makes you guilty of assault and battery upon her.
I defended myself by pushing her away from me. And
Well, go ahead, you may voir dire. I need more than that.
Was there some back and forth between you and Megan?
yes, we were arguing.
Did you feel that you were in danger? Or were you just angry?
Why didn't we talk?
That wasn't anticipating that question. We talked about you saying.
Were there times when you did not act in self-defense, when you
Yes.
pushed her and shoved her?
Yes.
So you retaliated basically, is that correct, by pushing or shoving her?
Yes.
Okay, I'm satisfied.
All right, thank
Are
you.
you satisfied?
People are satisfied.
Is the defense satisfied?
I'm satisfied.
The court is satisfied that your guilty plea was knowingly, voluntarily, and understandably made, that there is an accurate factual basis to warrant a finding of guilty because on the date and location alleged in the complaint, you did push or shove Megan Myron. That did not constitute self-defense in the form of retaliation during an angry argument. Therefore, a judgment of guilty will be rendered subject to being set aside under MCL 769.4A. Anything by the defense? Are you ready to proceed to sentencing today?
I am.
Are you also?
People are.
Okay, anything but from the defense before I pronounce sentence?
Yes, Your Honor, as Mr. Ackley has indicated, this is a long-term relationship. Parties don't have any children in common, but they do have children that they raise together. Mr. Ackley has no criminal history whatsoever. He's employed at Carmoose and has been for an extended period of time, so he has stable employment. He understands the circumstances that got him into this situation. I think better than most of the people that I've talked to, he's already taken action to correct that by getting into counseling and making some life changes that will probably solve the situation going forward. I would ask that the court impose no upfront jail time. He does have credit for 1 day at the jail, and that the court place him on a period of probation. And I've already made the referral to specialty court. Again, I think we'll resolve the situation to the satisfaction of the people and the parties, and that we won't be seeing Mr. Ackley in this situation again.
Thank you. Anything on behalf of the people, Mr. Noble?
Donna, this is an unfortunate but all too common, fairly straightforward situation. You know what? It's unfortunate that it happens as often as it does. I don't know how many of these a week we have to deal with, but it seems like all the time we're dealing with domestic violence. It's part. It's unfortunate. But hopefully, that's why the legislature created 769, that statute. Hopefully, Mr. Ackley will learn from this. Hopefully, if substances are a part of his life, they stop becoming a part of his life, and they will stop making. If he's not consuming, maybe he won't make bad choices. We all have a tendency to do that at one point or another if we consume intoxicants. So hopefully we'll get that under control if it needs to be got under control, and we will not be back here because of a situation like this. And, you know, that's all we can say about these things is hopefully they won't continue, because if they do, you know, domestic violence second is a pretty serious misdemeanor, and domestic violence third is a pretty serious felony. So we just hope it never gets down that path. Thank you.
And perhaps I could also mention that we have an understanding that there'll be a joint request to allow contact going forward.
Yes, I received a letter. It was either like right at the end of last week or the first of this week from Ms. Myron requesting that contact occur, and the people have no objection to that.
The court has not received the victim impact statement. Did you receive one of those?
We've spoken with her this morning, among other things, Mike Behind Victims' Rights, and she was supportive of this plea, and the messages that I got is that it was supportive of that. And here's
She's not requesting to be present.
She requests that at that point that I'm aware of.
She does have a written letter that is received and dated August 2nd. She says, I, Megan Myron, would like the no contact order placed on Caleb Ackley to be lifted. I would like it to be lifted due to the fact that Caleb is currently seeking counseling and staying sober, while Caleb is seeking treatment and not drinking. I feel safe. Okay. All right. Thank you. Anything further from the defense?
No, Your Honor.
Okay. Ackley, anything you want to say?
No, sir.
Often we do things under the influence that we probably wouldn't do otherwise, but all that does is show us that sometimes there's an inclination to control other people, whether you're drinking or not. It just comes out when you're drinking. When you try to control someone else's behavior, that's a recipe for failure. It just doesn't work. You have to work together with people to build relationships. And I know you know a lot of this, and I'm sure you will get it in counseling too, but it's very important to understand that sometimes we just don't realize what we're doing affects people in such a negative way. And then when we step back from it, we realize that just yelling at someone, form of violence. Because people can agree or disagree, but when it gets into a heated argument, nobody's in control. So I do recognize that you are employed well, and you have no prior record that I'm aware of, and that you're otherwise a good person. As long as you stay away from substances, you can continue to be that person. So I will place you on a 769-4A probation for 18 months. Part of the conditions are that you pay fines and costs of $350. Unless that's 93 days in jail with credit for one served and credit for one served. And I'll suspend the balance of the jail time on condition you successfully complete the probation. You cannot violate the criminal laws of any state or municipality or federal government. You are not to leave the state without consent of the court. report to the probation officer as directed and notify the court of any change of address or employment status. Pay the fines, costs, and fees within 12 months. As I said, those are $350 plus $125 in justice fees. I'm required to add it case by law. $25 a month probation oversight fee. During this probation for 18 months, you are prohibited from using or consuming intoxicants, illicit controlled substances, or marijuana. Positive test is a violation of your probation. So what you put in your body is your responsibility. If it's a medication that contains alcohol, you are not allowed to take that without medical and probation officer approval in advance. Over-the-counter stuff like cough syrup or mouthwash often contains alcohol. But if you test positive for alcohol, we don't care where it came from. It will be a violation of your probation that could subject you to jail. So I want you to be aware of that ahead of time, because I want to be fair with you on that. You are subject to testing at any time. A positive test, again, is a violation of your probation. Follow all your counseling recommendations and sign releases so we can monitor your progress, and your probation officer will go over with you. We'll keep any information from counseling completely confidential in a separate file that's non-public. You are subject to a search at any time, and you shall not display any threatening, assaultive, or intimidating behavior toward anyone. Take a deep breath, count to 10, and then have your conversation, okay? This will be put in writing. If you successfully complete this probation, the charge will be dismissed, and this will not be a public record of any conviction, okay?
Copy from the people.
All right, thank you, Mr. Ackley. You'll be meeting with the staff to set up an appointment for your interviews, okay?
Just wait for his paperwork to come back.
Yeah, probably.
Your Honor, we're completing his intake screening right now, so you can just come up to the court suite.
Okay, very well. We'll have you do that.
Your Honor, did we say specifically that contact is allowed?
I didn't enter an order of no contact, so it's considered lifted.
Okay.
Next matter is People versus Braden Alexander Black, file number 2107109. Is Mr. Black available?
He was here this morning. We're going to adjourn that, Your Honor.
Yes, this is
Okay.
one we're adjourning. We have the full list of victims now, and I can speak with all of those victims because they're quite numerous. I can share the full report now with Mrs. Denholm that I just got yesterday. And then hopefully we can set that for plea and sentence and it'll resolve this.
All right, that matter stands adjourned.
Thank you.
You'll let me know when you're ready with Mr. Peak.
Okay. I will. I'll call him right now. That was him trying to call me on the phone a minute ago. I had a printout showing where Mr. Goodrow is.
Yeah.
I-
He's in jail last night.
Yeah. Well, actually, he's not in jail.
We got it.
He's out of custody. Yeah.
I believe I issued a bench warrant with no bond
No
on
bond,
him,
yep.
and that's the way it stands.
That's fine.
Okay.
He's gonna put that in the court file.
Where is he?
He's in North Dakota.
It's my understanding he got arrested there too.
Correct. Yeah, he was in jail. He's out of jail, but he has pending charges. So.
All right, well. The way the cookie goes.
When he shows back up, we'll deal with it.
Okay. Alright. I can't hear them talking.
Okay, can you hear us?
I am here.
Okay, sorry, we're keeping you waiting here. We need to round up all of the judge and everybody else.
Okay.
Yeah, but it's still way less time than driving back up here.
Yes, ma'am. 12-hour trip.
Cats.
Apologies, I went that direction. Okay. Mr. Noble said he would not be returning.
That's fine. We on the record?
Yep.
Okay. Recalling the matter of People versus Michael James Peak, file number 2108130. Is Mr. Peak on Zoom?
Yeah, I'm here.
Okay, please turn on your video.
If I knew how to do that, I would.
Down in the bottom corner, there's like a little camera with a red slash across it.
Oh, there we go.
Yeah,
There we go.
good.
Thank you. Thank you. Ms. Denholm, what is the defense's position on this matter at this time?
Your Honor, pursuant to the plea agreement, Mr. Peak will be pleading guilty to count 1 as charged, with the understanding that there would be no upfront jail time and that there would be permission to remain outside the state of Missouri. We're anticipating also that the court would impose a term of probation that would end at the time that the fines and fees are paid.
All right. I'm not really looking at a probation in this matter, just so the parties are aware.
All right, thank you.
All right. Mr. Peak, you've heard the plea agreement. Is that your understanding of the plea agreement?
Yes, sir.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, I just don't want no jail time and stay in Missouri.
And Your Honor, we should also say for the record that Mr. Peak understands that the weapon involved will be forfeit.
Okay. All right.
Yes.
And again, the guilty plea offered by your lawyer is made with your consent, right?
Correct.
Has anyone threatened or forced you to get you to plead guilty?
No, sir.
Are you pleading guilty freely and voluntarily and of your own choice?
Yes, sir.
All right. What type of vehicle were you driving in Mueller Township of Schoolcraft County back on August 1st when this happened?
I was in my girlfriend's car as a GMC Envoy 2005.
And were you the passenger?
Yes, sir.
And did you have a 9mm Ruger pistol in the vehicle?
Yes, sir.
Where was it located?
Underneath the seat.
Did you have a Michigan concealed weapons license permit to have that weapon in the vehicle?
Sorry, can you repeat that? I didn't hear that.
Did you have a state of Michigan concealed weapons permit that would allow you to have that vehicle, that weapon in that vehicle?
No, sir. I'm from the state of Missouri, so I would not have a license, and I was only up there visiting.
Was the weapon loaded or unloaded?
It was unloaded.
Okay, thank you. Are you
welcome.
satisfied with the record?
There would be one follow-up question I would have for sure.
Okay, go ahead.
Because there's reciprocity issues, did you have a concealed weapons permit in the state of Missouri?
I do not have a permit, but it was registered, but the cop was trying to tell me that it wasn't. And I don't know exactly what was going on with that, really, because I was completely confused because I never been through this before. So in the state of Missouri, we're allowed to carry a gun on us with or without a permit, long as it's not in a public area or public places or anything like that, is what I'm understanding.
And therein lies the difference, Your Honor. In Michigan, once you go into the car, it's considered a concealed weapon, as the court's aware.
And it may be in
That's the
Missouri
difference.
as well. And we don't know that. But in any event, are you satisfied with the record?
I am, Your Honor.
Are you also?
I am.
The court is satisfied that your guilty plea was knowingly, voluntarily, and understandably made, and that there is an accurate factual basis to warrant a finding of guilty because on the date and location alleged in the complaint, you did have a firearm in a vehicle. Therefore, a judgment of guilty will be rendered based on the facts you've stated and the reasonable inferences the court makes from those facts and pursuant to the plea agreement. Anything further you wish to state, Ms. Denholm?
Your Honor, I would indicate that Mr. Peak has no prior criminal history. He has a long history of employment. This is an unfortunate misunderstanding, but I believe that this is that the resolution that we've arrived at is a reasonable resolution of the situation.
Anything further?
Your Honor, weapons, there's especially firearms and even more especially pistols have a whole host of rules that follow them. And whether you agree, disagree, whatever, that's not really for me to decide. Each state has their own rules. And as far as I know, Michigan recognizes every state's concealed weapons permit, as far as I know. And so if you have a concealed weapon permit in Michigan, perfectly legal to carry in a car. But in Michigan, entering a car makes the weapon concealed, which means if you don't have a concealed weapons permit, makes it a felony. I understand that may not be the case in every state. Some states don't require that. Some states have completely different rules. I know several that do. But the fact is, when you're in Michigan, it's incumbent upon you to know those rules. And so I think we've come to a reasonable resolution because based on what I know about 50 states' guns laws, this would have been legal in Missouri and not legal in Michigan. And so I I don't think it's reasonable for me to exercise state authority and convict this gentleman of a felony when he had a reasonable belief to believe that this was at least somewhat legal in his own state. But you got to know where you're at and know what the rules are. That's why it, gets tricky.
But I get having it on your person, but having it in a vehicle is the concern the court has.
Yeah, a lot of states, when you go into a car, it's not considered concealed like it is in Michigan. Michigan, entering the car makes it concealed, but not every state's like that. And so that's why it's incumbent upon people to know which state they're in and which state that law applies to. Or the easy way, get a concealed weapons permit, and then in Michigan, carry your weapon concealed perfectly legally,
Okay.
even in your home state.
Thank you. Mr. Peak, is there anything you wish to state before I pronounce sentence in this matter?
It's just, I didn't understand the Michigan state laws when it comes to guns and all that. That's where I'm just confused. I should have read up on it as a responsible person before I came in the state of Michigan. My apologies. But other than that, I just didn't understand the state laws of the Michigan state laws of their gun rules.
Okay, thank you. I'll take that into consideration. It'll be the sentence and judgment of the court, and I will follow the plea agreement that you be sentenced to fines and costs of $350. There's $125 in justice fees I'm required to add in every case, or 35 days in jail. How much, the total is $475. How much time do you need to pay that?
Well, I get child support taken out. So every 2 weeks when I get paid, and that's just about $400. So it might take a little bit of time to get me to be able to pay that.
I'll give you 90 days to pay the fines, costs, and fees. Is that doable for you?
Yeah, I could get that done. Thank you, sir.
Okay, and you can make installments. Don't wait till the 90 days is up and you can't come up with the money. So make sure that you pace your income accordingly, because I cannot give you an extension on this. It has to be paid within 90, or you'll have to report to do 35 days. Court will order the weapon or firearm, in this case, the 9mm Ruger pistol, will be forfeited to the state.
And I'll provide an order for the court to sign to that effect.
Thank you. Anything further?
Nothing from the people.
Anything further? All right, we'll mail you a copy to the address you've given here today, 112 Eagle Ridge, Robertsville, Missouri. If you change your mailing address, you must immediately notify the court until the fines and costs are paid, okay?
Okay, thank you, sir.
Thank you. Have a great day.
You too, sir.
And I'll put a note in the file that says we won't object to that.